Welcome to Thursfields Talk Legal. This is a new series of podcasts from one of the leading law firms in the Midlands. I'm Steve Dyson, and I'm the journalist who's going to be talking to a range of solicitors at Thursfields on legal topics of a wide interest to the public or businesses in this area. Please bear with us. All our recordings are carried out remotely, online, and that makes sure that we keep to the government's current stay-at-home advice during COVID-19. Today's episode is all about mergers and acquisitions, and I'm going to be speaking to Philip Chapman. Philip's a director in the corporate department at Thursfields Solicitors. Hello to you, Philip.
Hi, Steve. Thanks for letting me take part.
No problems, Philip. I want to explore, Philip, the subject of mergers and acquisitions with you. So what I'm talking about is when a company or a person is buying or selling a business. Now, in some ways, to someone on the high street like myself, this sounds like a simple activity. You want something, you agree a price, you pay the money, and the ownership of a business changes hands. But I understand it's a little bit more complicated than that, isn't it?
Yes, it can be quite complicated. You followed a detailed process, the purpose of which really is to protect the interests of both the seller and the buyer, but also other parties who may have interests in the transaction, such as banks or investors, or even employees who have options in the shareholding of the company. There are two types of mergers and acquisition, the first being a share sale and the second being an asset sale. Okay,
so it does sound like a bit more of a detailed process as to what I originally thought. So let's explore it a little bit. First of all, tell us a little bit about the differences between what you've just mentioned there. I think you mentioned a share sale or an asset sale. What's the main differences there?
Yeah, so the most commonplace one would be a share sale, in which the buyer would acquire all of the shares, normally all of the shares, in the target company. By doing that, they gain ownership of all of the assets of the company, but by the same token, they also gain ownership of all the potential and current liabilities of the company. So that's the first one. And the second one, with an asset sale, the advantage of that is that you're choosing the assets of the target company that you wish to buy, and you leave the assets that you don't want to buy. The disadvantage of that is that the ownership of those assets doesn't automatically transfer to the buyer. So you'd have to, for example, novate or assign contracts. And there's also the thorny issue of transferring employees.
Oh, that's a clear description of the two different types. And obviously, either sale, from what you're saying just there, either sale is going to have to involve a multitude of different legal agreements and documents. Can you explain the main types of documents involved in mergers and acquisitions?
Yeah, so the initial documents would be the heads of terms, which set out the overall commercial terms of the deal, such as the price, the payment terms, any restrictions on the seller, the fact that there will be a detailed share purchase or asset purchase agreement, and due diligence into the target company. Secondly, there would be an exclusivity agreement, which would bind the seller into a period of time in which they cannot talk to any other potential buyers, and also a confidentiality agreement, which binds the two parties to keeping all matters confidential during the sale and purchase process. So leading on from those, you have further more substantial documents which are legally binding, such as disclosure letters, share purchase agreements, asset purchase agreements, and so forth.
Now, listening to you, Philip, there, it's clear that there's several important legal documents involved. And maybe to draw a picture for our listeners, you can tell us how these different documents work and how the process works in a summary, if you like, a step-by-step description of the mergers and acquisitions process.
Yeah, so once the heads of terms have been signed and agreed, typically the buyer's solicitor would issue a legal due diligence questionnaire to the seller's solicitor, The questionnaire would involve inquiries about the target company's ownership, their accounts, contracts, employee arrangements, insurance contracts, tax arrangements, all these sort of things which the buyer will need to know about and to mitigate any risk going forward, and any issues that do come up will affect the main documents later on down the process.
Okay, so there's various stages which each of them can get quite involved depending on their nature. And perhaps let's go into an example just to explain to our listeners how detailed they can get. So for instance, I understand there's a due diligence procedure, which itself can be quite a complex process, and that needs discussions around liabilities, warranties and potential indemnities. Is that right?
Yes, that's quite right. So once you receive the responses to the due diligence and the solicitor's team has gone through the responses, it may well be that certain potential or current claims come to light against the target company, and in which case the buyer will need to assess how they are going to mitigate their risk and exposure, which might involve requesting the seller to sign up to certain warranties and indemnities. The seller, by turn, will also seek to limit their exposure, and they can limit their exposure to that by limiting the warranty or indemnity by time or amount, the amount often being the value of the consideration that they are receiving for their business or shares. And leading on from that, the seller will often produce what is called a disclosure letter, which qualifies any warranties that they cannot warrant, which are included in the share purchase agreement or asset purchase agreement.
Yeah, whilst it's all quite detailed, it does sound sensible as you're going on into this into the detail, because the processes mean that everyone knows what's happening, and I guess that means everyone understands the exact value of the sale or the purchase, and if or what any potential problems might be. At the moment, of course, everyone's quite worried about COVID-19, and as a result, the whole subject of pandemics. Does that kind of issue come into play with mergers and acquisitions?
Yes, it does, absolutely. We are currently talking to many of our clients about how they are going to mitigate their exposure and their business exposure to the coronavirus pandemic. So what we're saying is, in advance of, say, a seller receiving due diligence inquiries, they put in place contingency plans to deal with the pandemic. And by the same token, we're saying to the buyer, any potential buyers, that they seek specific indemnities against sellers who perhaps haven't put in place any contingency plans. And for both parties, it is also important that any disclosure letter that is produced is absolutely detailed in its explanation of those COVID-19 contingency plans.
I understand. So all these steps take place, these documents are studied, are created, are signed and agreed, and any contingencies are known, and so that people are aware of the risks and the mitigations which have taken place. So hopefully once all those processes are agreed, the mergers and acquisitions deal is struck with a final price and a change of ownership takes place. Is that right?
Yes, that's right. So the whole transaction, once the documents are agreed, leads to signing of board minutes, stock transfer forms, company's house filings, things like that. The completion meeting can be held remotely, during which the sellers simply sign their documents and the respective solicitors then date the documents over the telephone. Or the old-fashioned method is to have a physical meeting in boardroom, and once the matter is completed, often there's a pop of champagne or something like that.
Well, that sounds like a nice way to end it off. Maybe I can come along and report on one of those final sessions where those glasses are chinked together. That would be nice.
You're very welcome.
And Finally, Philip, if people need help with mergers and acquisitions, how can they get in touch with an expert at Thursfields? Who should they call or email?
Yes, so my number is 0121 227 3879, and my email address is pchapman@thursfields.co.uk, and we have a number of corporate lawyers who'd be very happy to help.
Philip Chapman, Director in the Corporate Department at Thursfields Solicitors. Many thanks for joining us and for giving us that initial outline so that people can understand what goes on in the mergers and acquisitions process. Thank you for joining us on Thursfields Talk Legal.
Thank you, Steve.
Hopefully what Philip had to say there about mergers and acquisitions has given you a view of the different things that businesses need to find out about if they're thinking of selling or indeed buying another business. We'll be back soon to talk to another legal expert here at Thursfields about a different interesting aspect of the legal world. Thursfields Talk Legal. Thanks for listening.